Let's change it up. Let's go up to Lake County, Ohio, Judge Culotta.
R1421. The defendant is present with counsel Michael Goldberg. A 6-count indictment was filed in this case on October 8, 2025. Counts 1, 2, and 3 are illegal use of a minor or impaired person in nudity-oriented material or performance, felonies of the second degree, in violation of Revised Code 2907.323A1 with forfeiture specifications. Counts 4, 5, and 6 are voyeurism felonies of the fifth degree in violation of Revised Code 2907.08C. The state has offered for the defendant to plead guilty to counts 3, 4, and 5 with the forfeiture specification to count 3. It is the state's understanding that today the defendant would like to withdraw his previously entered pleas of not guilty and plead guilty to these 3 counts. It is the state's understanding that the defendant will also voluntarily forfeit an additional cell phone and Android that is not included in the forfeiture specification, and there is no agreement as to sentencing.
Mr. Goldberg, does that sound accurate?
It does, Your Honor. I'll just also state for the record that I've had a chance to meet with Ms. Gold on a couple of occasions. I've reviewed all the evidence, both that she could provide to me in the regular channel of discovery and that was of a more sensitive, privileged nature. I've discussed everything with my client, and he understands his constitutional statutory rights. He understands the benefits of this plea and the potential penalties, and he will make a knowing and voluntary plea here this morning.
Thank you. Scolds, it's my understanding that the victim would like to be addressed to court. Is that accurate?
Yes, Your Honor.
We'll hear from them at this time. So whoever it is that wanted to address the court, state your full name, please, so we know who's speaking, and you can say whatever you'd like me to know.
My name is Giovanna Priola.
What is it?
Giovanna Priola.
Can you spell your last name?
Priola.
Thank you.
Your Honor, I feel the plea deal is too lenient because most days I still have trouble showering, and most nights I still have issues sleeping, along with nightmares even 6 months later. I feel due to the overwhelming amount of evidence, it should go to trial, and the defendant should be held responsible for all 3 counts on both charges. I feel there's absolutely no reason to drop any charges or lessen them because what the defendant did completely changed my life and cannot be undone.
All right, thank you. Mr. Jefferson, were you able to hear what the prosecutor said earlier here this morning, as well as what your attorney just said?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and plead guilty to count 3, 4, and 5. And I'll go over those charges with you. Remaining counts will get dismissed. We would defer sentencing to get some reports and evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your guilty plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I'm going to ask you a series of questions. If at any point when I'm asking you these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
Let's get started then. How old are you?
33?
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, I do not.
Are you a U.S. citizen?
Yes.
Now, before you came to court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
Nothing.
Now, you should have been served. You would have been served with a copy of this indictment. It looks like you got it sometime back about the first, second week of October. Do you remember that, this document that sets forth the charges?
Yes, I do.
Did you have a chance at some point to look that over?
Yes.
Now, in this indictment, you're charged with 6 counts. You're pleading guilty to 3 of those. Count 3, the first count you're pleading guilty to, alleges, and what you'll be admitting to, is on or about May 23rd, 2025 in Wickliffe Lake County, Ohio, that you did photograph a minor who is not your child or ward. You did that, photographed them in a state of nudity, or you created, directed, produced, or transferred any material or performance that shows the minor in a state of nudity. That conduct constitutes the offense of illegal use of a minor in a nudity-oriented material or performance. It's a felony of the 2nd degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Charge also carries with it a forfeiture specification, which alleges during the commission of the offense that you had in your possession a black Samsung phone which was used as an instrumentality. An instrumentality is some type of property that's used to facilitate the commission of an offense. Here it's alleged you used this black Samsung phone to commit or facilitate the commission of the offense I just read to you. The purpose of the specification is that at the time of sentencing, any right, title, or interest you have in that property will be forfeited to the state of Ohio. Do you understand that?
Yes, Your Honor.
For the purpose of them disposing of it and getting rid of it. Any questions then about count 3 with the forfeiture specification?
No, Your Honor.
And count 4 is the next charge you're pleading guilty to. Counts 4 and 5 actually, they're the same charge, just different dates. Count 4 is alleged to have occurred on May 17th, 2025. Count 5, the conduct's alleged to have occurred on May 22nd, 2025. And in both of those counts, it's alleged that in Wickliffe Lake County, Ohio, that you did knowingly commit trespass or otherwise secretly or surreptitiously videotape, film, photograph, or otherwise record a minor with initials of GP in a place where a person has a reasonable expectation of privacy, and you did it for the purpose of viewing the private areas of the minor. That conduct constitutes the offense of voyeurism. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to counts 4 and 5?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, there are 3 other charges in the indictment that are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Any questions about any of those 3 charges?
No, Your Honor.
Well, then before I can accept your guilty plea to the 3 charges I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to a trial. Trial could be to me as a judge, where I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also do have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence. Then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be a unanimous decision, which means all 3 jurors would have to agree together, one way or the other, whether you're guilty or not guilty of these charges. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty you're giving up your right
Yes.
to have a trial in this case?
Yes, Your Honor.
Now, if we had a trial, you'd have the right to have an attorney represent you at the trial. If you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
Yes, Your Honor.
Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, first the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges. That presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when we speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of those charges I just read to you beyond any reasonable doubt before you could ever be found guilty of any of those charges at a trial. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt?
Yes, Your Honor.
Now, in order to do that, or at least try to do that if we had a trial, the prosecutor would be bringing witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask him anything he wanted to, within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you at trial?
Yes, Your Honor.
Now, you'd also have the right at a trial, you can call your own witnesses to come to court to testify for you if you wanted to, and answer your lawyer's questions. Now, you're not required to do that. You don't have to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court to issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that is your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if you went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up any right you have to appeal a guilty finding that I will enter if I accept your plea, as well as any other issues that you could have raised or brought to my attention that could be raised in the future. You're giving up all those. Do you understand that?
Yes,
Well, not any sentencing issues, but any rights, any issues you could have raised up to this time. That's what I
Yes.
meant to say. You understand that?
Yes, Your Honor.
All right. Are there any questions at all then regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No questions,
Do
Your
you
Honor.
understand them all?
Yes.
Do you still want to plead guilty?
Yes, Your Honor.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty in count 3 to a felony of the second degree. This offense is what we call a qualifying offense, and it's simply called a qualifying offense because it was committed after March 22nd of 2019. After that date, all felonies of the first or second degree are subject to indefinite sentencing. Indefinite sentencing means that a minimum sentence and a maximum sentence will be imposed if a prison sentence is imposed. In this particular matter, if a prison sentence was imposed, I would select a number in the range of 2 to 8, 2, 3, 4, 5, 6, 7, 8. And that number, whichever number I selected, would be the minimum sentence you would have to serve. You understand that?
Yes, Your Honor.
Now, in order to determine the maximum sentence, it's simply a mathematical formula. You take half of whatever the minimum sentence is I select, you add that half to the minimum sentence, and that becomes the maximum. So I'm going to give you a few examples just to make sure we understand. If I selected 2 years as the minimum sentence, half of that is 1. You'd add the 1 to the 2. Your maximum is 3. So it would be an indefinite sentence of 2 to a maximum of 3 years. If I selected 6 as the minimum, half of that is 3. You'd add that to the 6. The maximum would be 9. So it would be an indefinite sentence of minimum of 6, maximum of 9. And likewise, if I selected 8, which would be the maximum for the minimum sentence, half of that is 4. You'd add that to the 8. Your maximum would be 12. So it'll be the maximum sentence you face on count 3 is an indefinite prison term of a minimum of 8 years, maximum of 12 years. Do you understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, the other remaining counts, I think they're 4 and 5. Is that correct?
Yes, Your Honor.
4 and 5 are felonies of the 5th degree. Those are each punishable by a possible term in prison of a minimum of 6 months, a a maximum of 12 months or any whole number in that range. So if I imposed a prison sentence, I'd select one of those numbers, 6 through 12, and that'd be the number of months you'd have to serve for that particular count. Do you understand that?
Yes, Your Honor.
Now, since there are 3 separate offenses here, if I impose a prison sentence, I would impose it on each count in the manner that I just described. And then as the judge, I had the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together. You'd serve them at the same time. Consecutive means one after the other. So you'd serve, if all 3 were consecutive, you'd serve the prison terms on the felonies of the 5th degree first, whatever those were. Then you'd serve, after you completed that, the indefinite sentence on count 3. You understand that?
Yes, Your Honor.
So in this particular case, if I impose the maximum sentence on each count, the 8 to 12 plus 12 plus 12, 8 to 12 years plus 12 months plus 12 months, the maximum sentence you face in this case is an indefinite prison term of a minimum of 10 years, maximum of 14 years in prison. You understand that?
Yes, Your Honor.
Now, are you currently on probation or parole or any type of supervision in any of the courts or agencies?
I am on GPS ankle monitoring.
That's for this case, though, right?
Yes.
So that's a bond condition. I'm talking about for other cases that may have occurred previously.
No.
So you're not on probation to another court for any other prior case or
No, Your
post-release
Honor.
control or anything like that? Do you have any other charges pending against you anywhere else?
No.
If a prison sentence is imposed in this case, upon your release from prison, you would be placed on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you completed whatever the prison sentence was. And in this particular case, it would be 5 years. It would be mandatory, and it would be 5 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control and you ever violated any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could order more restrictive sanctions against you, that you serve more restrictive sanctions, including local jail time. Or I could terminate or end your probation at that point and send you to prison then. If I did it at that point, again, it could be for that period of time I told you before, up to a maximum of indefinite term of 10, maximum of 14 years. Do you understand that?
Yes, Your Honor.
That would also be, or could also be, consecutive to any other prison sentence you may be serving for some other case if something else happened, or that you're being sentenced to at that time if something new happened. You understand that?
Yes, Your Honor.
Now, in regards to the indefinite sentence that I just explained to you for count 3, there's some other things I need to tell you about that. In terms of that minimum sentence, whatever the minimum sentence is that is imposed by the court, there is a presumption, a rebuttable presumption, I'll explain what that means, that you be released after you've served that period of time for the minimum sentence. Now, that's not guaranteed, but there's a presumption that you should be released. That presumption, however, could be overcome if the Department of Rehabilitation and Corrections, the prison system, is able to establish at a hearing that while you were confined, you violated rules of the institution, prison rules. You weren't sufficiently rehabilitated. You were a threat to the community. If anything like that was present, they would have a hearing. And if they were able to, which you would be present at, have a right to be present at least. If they were able to establish that at the hearing, then you wouldn't be released at the minimum sentence. You would remain in prison. They would select a new date that you could be, that you would be released, and that new date would be a presumption that you'd be released at that time. But the same procedure could be followed. Again, it's not guaranteed. If at a hearing they establish that you still were committing violations of the rules, you were a threat, you weren't sufficiently rehabilitated, they can keep you in prison again. However, under no circumstances can they keep you in beyond the maximum sentence. So, hypothetically, if I gave you the maximum sentence, 14 years, they'd have to be released you at that 14 years, even if you misbehave every day you were there. They'd have to release you at that point. You understand that?
Yes, Your Honor.
Also, if I did impose a prison sentence, you would have the ability to earn what is called good time credit, which could reduce the period of time that you serve in sentence, and that's done by participating in programs, etc. while you're in prison. Now, again, that's not guaranteed, but you would have the right to earn anywhere between 5 to 15% credit off your sentence. In terms of that the first issue I was explaining to you about the getting out at the minimum sentence, I had no say in that. I had nothing to do with that. In regards to this good time credit, if you did earn good time credit, there's a presumption that you should get it, but it's not guaranteed again. And in that regard, the prison officials would notify me or whoever's sitting here at that time in this seat, and it'd be up to the judge. If the judge wanted to not approve it, he would have or she would have a hearing, which you would be present at. And after that hearing, the judge could approve or disapprove of that credit. If there's no hearing, though, it has to be approved. You understand that?
Yes, Your Honor.
Now, in addition to the possible prison sentences that I just explained and the circumstances all about that, there's other sanctions that could be ordered. You could be fined in this case. Count 3, the felony in the second degree carries with it a possible fine of up to $15,000. The other 2 charges carry a possible fine of $2,500 each, so altogether is a maximum fine of $20,000. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay court costs or reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
You could also be ordered to pay restitution to the victim for an economic loss the victim may have suffered as a result of the conduct involved. Do you understand that?
Yes, Your Honor.
Also, in regards to the forfeiture specification, at the time of sentencing, you'll be ordered to forfeit the property that is described in that specification, and apparently there's also some agreement between the parties regarding another phone that's going to be forfeited at the time of sentencing. Do you understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Lastly, since you are pleading guilty to a sexually oriented offense, at the time of sentencing, you will be advised by the court of what your obligations will be to register as a sex offender. You'll be required to, you'll be classified as a Tier 2 sex offender, correct? Tier 2?
Yes, Your Honor.
Tier 2 sex offender, and you will be required to register in person at the sheriff, the county sheriff for the county where you reside, and then also where you work or go to school if that's applicable, if it's a different county. Do you understand that?
Yes, Your Honor.
And you'll be required to do that. I'm going to explain this in more detail at the time of sentencing, but it'll be every 180 days for 25 years. Do you understand that?
Yes, Your
Which would
Honor.
start after any incarceration, if any incarceration is imposed. Do you understand that?
Yes, Your Honor.
And again, you'll get more specific details about that. I just need to make sure at this point you understand that that's a consequence of and something that's going to happen as a result of pleading guilty here. Do you understand that?
Yes, Your Honor.
Now, a few moments ago I explained the possible prison sentence you face. I used the word possible. Prison is not mandatory with any of these charges. With each of these charges, you are eligible for probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means it'll be considered if that's what you're asking for. But I'll look at all the information presented and I'll make the decision I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, while you are eligible for community control sanctions, I need to advise you that count 3, the felony of the second degree, carries with it a presumption for prison, which means there is a presumption that the court would have to impose a prison term unless certain findings could be made by the court to overcome that presumption and allow me to put you on community control sanctions. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control sanctions, it could be for up to 5 years, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. Do you understand that?
Yes, Your Honor.
Further, if you are on probation, you violate any of the conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years if it wasn't originally 5 years. I could order more restrictive sanctions against you, including an order that you serve time in our Lake County jail, or I could terminate your probation and send you to prison at that point. And if I did it at that point, again, it would be for the same period of time, or it could be for the same period of time that I explained earlier, up to a maximum of an indefinite prison term of a minimum of 10 years, maximum of 14 years, which can also be consecutive to any other prison sentence that you may be serving for something else at that time, or you're being sentenced to. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you're going to have the right at that time to say anything you want, anything you'd like me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. Prosecutor has a right to recommend the sentence to the court. The victim has a right to speak at sentencing. Do you understand that?
Yes, Your Honor.
Do you understand that whatever anyone says at sentencing regarding what the sentence should be, it is just what I said. It's a recommendation. I don't have to follow any of the recommendations. Even if it's agreed to, I don't have to follow it. If I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Do you have any questions for me about the potential penalties you face by pleading guilty?
No, Your Honor. No
Understand all the
questions.
possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have him review everything with you, go over the reports, answer your questions?
Yes, Your Honor.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Has he or anyone else made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty here today?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering the guilty plea freely and voluntarily?
Yes, Your Honor.
All right, then, do you have any questions for me at this point regarding anything we've just talked about, regarding the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions at all for me?
No, Your Honor.
Do you need any more time to speak to your lawyer before we go forward with the actual plea?
No, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me, excuse me, what she believes the evidence would show if we had a trial. I want you to listen to her because then I got some follow-up questions for you about that, all right?
Yes, Your Honor.
Ms. Gold for the state.
Thank you, Your Honor. The facts would show that during the time frame in the indictment, the defendant was living with his ex-girlfriend Angela Priola and Miss Priola's 16-year-old daughter, minor victim GP. They resided at a house in Wickliffe, Lake County, Ohio. On May 17th, 2025, May 22nd, 2025, and May 23rd, 2025, the defendant set up his Samsung phone in the bathroom of the home where minor victim GP had a reasonable expectation of privacy to secretly record her. On each date, the defendant recorded video of minor victim GP going to the bathroom and or showering while she was in a state of nudity to view her private areas.
Mr. Jefferson, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as they were just presented? Are they true? Did you do what she said?
They are true, Your Honor.
Very well, then, regarding count 3, charging with illegal use of a minor in a nudity-oriented material or performance, a felony of the 2nd degree, what is your plea to that count?
Guilty.
What about the forfeiture specification regarding the use of the phone as an instrumentality? What is your plea to that?
Guilty.
As to counts 4 and 5, each charging with voyeurism, each felonies of the 5th degree, occurring on different days, what is your plea to each of those 2 counts?
Guilty.
All right, this time I have in my possession here a document called a written plea of guilty and judgment entry, which sets forth and explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document, what it says, that you sign it here in open court. Excuse me. Now, my understanding is that before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Goldberg, is that accurate? Did you review this with Mr. Jefferson, read it over to him, and answer his questions?
That is accurate, and I did do so, Your Honor.
And did he indicate an understanding of that to you when you did that?
Yes, he did.
Is that correct, Mr. Jefferson?
Yes, Your Honor.
So you understand what the document says?
Yes, Your Honor.
Any questions for me?
No questions.
It also appears that you signed the document a couple times. Did you in fact sign it?
Yes, I did.
You witnessed that, Mr. Goldberg?
Yes, Your Honor.
Ms. Gold, you as well?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, advised of all his constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 1, illegal use of a minor in a nudity-oriented material or performance, felony of the second degree in violation of 2907.323A1 with the forfeiture specification, as well as counts 4 and 5, voyeurism, each felonies of the fifth degree and each in violation of 2907.08C. The remaining counts will get dismissed at sentencing, but I'm going to defer sentencing, order a pre-sentence report investigation, victim impact statements. Anything else you're requesting report-wise, Mr. Goldberg?
No, Your Honor.
As for bond, where were you this morning, Mr. Jefferson? You're supposed to be here at 9 o'clock for this sentencing. We had to sit around and wait for you to get here.
I apologize. I was not made aware of the time, just the date, and that is my fault. I was on my way to help.
You were made aware of just the date, so we're going to show up at 3 this afternoon, 6 o'clock tonight?
No,
So if you didn't know a time, you knew a date, why wouldn't you make some attempt to find out what that time was, or be here at midnight so you make sure you're here for sure?
that was a lack of responsibility on my
Yeah.
part.
I don't get it. You weren't told the time by who? Your lawyer, I guess you're saying?
Correct.
So why wouldn't you, when did you find out when the hearing was?
A few days ago. I had the dates wrong. I thought it was tomorrow. I thought tomorrow was the 23rd. I was incorrect.
It's the second time this has happened. No, these are serious charges here. I mean, I would think you'd take it serious.
I do, absolutely.
You don't.
Can I speak to this, Your Honor?
Sure.
So this was originally scheduled for the 19th to accommodate the state and the victim. It was moved to today. I did inform my client it was moved to the 23rd. He asked what time. I said it's going to be early. That's before I had the time. I never corresponded with him. Obviously, it's his responsibility to be here on time. When I called him this morning, he was indicating to me that he thought it was tomorrow. And he turned around and got here as quickly as he could. And so that's what happened. And, you know, to the extent that I didn't give him the exact time, that's my fault, but we know that it's ultimately...
Yeah, but if he gets a date and he has a court date and doesn't have a time, the first thing he should be doing is getting on the phone saying, what time is this hearing? When were you going to show up? So even if you thought it was tomorrow, when were you going to show up tomorrow?
I was going to reach out to my attorney today and ask for a time.
Well, again, if you're taking it seriously, you would have done it the day you got the notice instead of waiting till a day before to do it.
I would just state, Your Honor, that he's taken this very seriously. He's agreed to a forfeiture that's outside of the indictment. He's shown up at my office every single time, and this is, I believe, even though it comes on a very serious matter, he made an honest mistake.
Now, will the court will continue defendant's bond and order of cognizance with an order that the defendant have no contact with the victim or the victim's family, and follow all terms and conditions of the protection order. So, Mr. Jefferson, the matter is being referred to the probation department. The reason that's going there so they can prepare a pre-sentence investigation. The way they get the information they need to prepare this report is they're going to conduct an interview with you. It's important that you show up on the right day, at the right time, for the purpose of that interview. Because if you don't show up, then they're not able to, and they don't have an interview, they're not able to do a report. And without a report, I'm not even able to consider probation as an option. So if you don't know when it is, if you don't know the time, it's your responsibility to find that out. If you think it's the next day and you don't show up, you're out of luck. So you better be damn well sure you know what date it is and you show up at that time. It's also important that you're open and honest with them when you meet with them, because they're going to check and verify everything you tell them. And if they learn you're misleading them in any way, they'll let me know, and I certainly would consider that as sentencing. You understand that?
Yes, Your Honor.
So you're going to leave here now, you're going to go over to the probation department, you're going to fill out some initial paperwork, and you're going to get a date to come back for the interview, so make sure you go there when you leave here right now. You know where that is, Mr. Goldberg, right?
Yes, Your Honor.
So your lawyer will bring you over there or tell you where to go, but make sure you go there when you leave here now.
Yes, Your Honor.
Mr. Gold, anything else? Ms. Gold, anything else for the record?
Your Honor, because the defendant is on an OR bond, I would ask if we could put the sentencing
Oh, yeah,
date on
I
the
will do
record.
that. When is that, Mr.?
February 9th,
Right.
3 o'clock, sir.
So your sentencing is February 9th at 3 p.m. That's here. So that's what time you need to be here for your next court date. Again, this OR bond means you have to appear at all future court dates, and if you fail to do that, you can be prosecuted for a new felony and get up to 18 months in prison on that, which could be consecutive to anything that happens on the original charges. So it's obviously important to show up at all future court dates. But again, before that February 9th date, you're going to need to go to probation department, so make sure you do that as well.
Yes, sir.
All right. Mr. Goldberg, anything else?
No, Your Honor, thank you.
Thank you.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.